Good morning, everyone. Welcome to the ELU. We're just going to give it 2 minutes to allow more people to join. Good morning, everyone. I think we've got enough people who've joined online to kick off. Welcome to the Employment Law Update. I can't believe it, it's our last one for the year. I think we've got some particularly interesting cases to discuss this morning. Probably the standout one is the recent Constitutional Court judgment in Van Wyk dealing with parental leave. So that's the first case we will be kicking off with. My name is Helen Wilsonach, and I'll be facilitating this morning's update. I'm joined by my colleagues in our employment and benefits practice. I think for those of you who are regular attendees at the ELU, I think everyone here will be a very familiar face, but we'll introduce you as we get there. Before we begin, I'd just like to run through some basic housekeeping matters. As participants, you'll be automatically muted and the chat functionality has been disabled. But if you've got any questions, please just pop them in the Q&A tab and we will hopefully get to as many of them as we can. We won't be providing written responses to questions, but the webinar is being recorded and it will be available on our website at www.bowmanslaw.com. In addition, as we always do, we will be sending you a high-level summary of the cases we discuss, as well as the key takeaways, and we'll get those to you early next week. So I think without further ado, let's begin. Before we get into the first of our 10 cases, though, we're going to just take a quick tour through the recent updates to the Code of Good Practice on dismissals. I'm going to hand over to my partner, Talita Loubser, who I know is a very familiar face to everyone, to take us through that. Thanks, Talita.
Good morning, everyone. Thanks, Helen. Yes, you will all be aware that there is a new Code of Good Practice on dismissal, and this was issued, I think, mainly with the aim to ensure that everyone is now aligned on what a fair process means in the case of the recognized grounds for dismissal. Over the years, there's been many developments regarding what is required in order to ensure fairness in how we deal with cases of misconduct, poor work performance, ill health, and operational requirements. And interestingly, although the court in Avril Elizabeth said that in employment relations, there isn't a requirement for a very formalistic criminal court type inquiry process. And even though the previous Code of Good Practice actually said, what is required is an investigation, the way in which employers' policies and also the CCMA has interpreted what constitutes a fair process has been very rigid. And one of the aims of this code is to say this is the standard that we require in relation to fairness. Importantly, in the case of misconduct, it doesn't need to be this very acrimonious, formalistic, disciplinary process. The Code of Good Practice says there needs to be, obviously, a fair opportunity for the employee to state a case, to do so in a language that the employee is comfortable with, and to know what the allegations against her or him are, and to respond to those. But that doesn't mean this very, very acrimonious type process. It can happen in other ways. And what is critical is that there is an opportunity for reflection, I would imagine, both for the employer and for the employee. And sorry, I'm just taking off the poll that's coming up. And then for a considered decision to be taken. So specifically in relation to misconduct cases, I would suggest that you have a careful look at what is in the code and make sure that your policies and procedures align with these principles. There need to be a proper opportunity to make representations. There need to be an opportunity to carefully consider these allegations. And in appropriate circumstances, there may very well need to be a disciplinary inquiry. For example, if there is a serious dispute of fact, you may still want to retain that option. But I would recommend that you have a very careful look at your policies and procedures in order to ensure the required flexibility in order to deal with these kinds of matters. And also, yeah, a common sense approach as to what does it mean to have the opportunity to be heard. So in relation to misconduct, the principle of proving substantive fairness hasn't changed. There needs to be a rule in place. The rule must have been breached. The rule must be legitimate. All of those things are still intact. It is really in relation to process that it is now clear that that doesn't need to be as formal as we always thought. Then in relation to poor work performance, again, there is a distinction made between probation and what's required in relation to employees on probation, and the principle that there shouldn't be that probation periods mustn't be abused and used just to not follow a fair process in relation to probationary employees. You cannot just at the end of a probation period dismiss that person and then employ someone else on probation, and at the end of that period again dismiss. So that principle is made very clear. But again, you know, that process of dealing with the issues are now clear. You know, the employee needs to know where they are not performing in accordance with the standards. The standard needs to be explained and communicated. The employee must be given a reasonable opportunity to improve, and then a decision needs to be taken on the way forward. The code has now also stated expressly that we are dealing with senior employees, those employees know what the standards are that they are required to comply with. The code expressly says it's not necessary to warn them that they are performing badly. They can see from the financials of the company or the results that's there for everyone to see that they are not performing. So really the code has tried to bring together the principles from case law as it has developed over the years. Incapacity and ill health was dealt with, and then very interestingly, as a subsection of that incapacity section, it says an employee's incompatibility as manifested by an inability to work in harmony with an employer's business culture or with fellow employees can constitute a form of incapacity which may justify dismissal. For a very long time, there's been this debate about incompatibility and can we dismiss employees if things are just not working. So now it does say, yes, it may form or may constitute a form of incapacity. It is interesting what they look at, an inability to work in harmony with the employer's business culture or with fellow employees. So that is the context in which you could go an incompatibility route. Unfortunately, the code is silent on what process you would follow, but presumably it is a consultation type process where you explain your concerns. The employee has an opportunity to make representations and then a decision is taken. And then, interestingly, the provisions regarding retrenchment are now also included in this code. And it makes sense because this deals then comprehensively with the 4 reasons for dismissal and the processes that are required. So, yeah, that is, it is not a long code, 17 pages. I would recommend that you have a read through it carefully and have a look at where your policies are perhaps too rigid. Might be difficult where these policies are contained in collective agreements to effect immediate changes, but it is definitely a basis on which to approach the union and to discuss how your policies can actually keep up with the times as we now see in the code. Thanks, Helen.
Thanks, Talita. And of course, we've got the amendments to the Labour Relations Act, well, the proposed amendments. So it'll be interesting to see what happens in that space, and we'll definitely be covering it. Moving to the Constitutional Court's judgment in Van Wyk, which has fundamentally changed our leave landscape from maternity leave to and paternity leave to a gender-neutral landscape. It was quite interesting to lead in the poll. The first poll we put up was how many, what percentages of employers on this call have paid parental leave, and it was 93%, which actually was higher than I was expecting. We're going to put up another poll where we're going to ask you just to let us know what your current thinking approach is to amending your leave policy in light of the Van Wyk judgment. And it'll be interesting to see those numbers. But Talita, without further ado, I'm going to hand over to you to take us through the judgment.
Yes, thanks, Helen. Just as we thought, there can't be any more things happening in the area of unfair discrimination and employment equity targets and employment equity plans and all of those good things comes the Constitutional Court judgment in Van Wyk about a month ago. And in this case, Mr. Van Wyk and Mrs. Van Wyk approached the High Court in order to declare the sections dealing with maternity leave, adoption leave, commissioning maternity leave, and parental leave unconstitutional. Those are in the BCEA. And in conjunction with that, the corresponding provisions of the Unemployment Insurance Act. Mrs. Van Wyk runs 2 businesses, and she was pregnant and she wanted to return to full-time work at these 2 businesses as soon as she could after the birth of the baby. And Mr. Van Wyk said he will look after the baby when she returns to work. So he approached his employer and said he would like to have maternity leave in these circumstances. And the employer said, no, you can't have maternity leave. That is actually something that is there for the birth mother. But what you can have is the 10 days parental leave. And aggrieved with that response, they then went to the High Court and said that this is unconstitutional. It deprives couples of making their own arrangements and to choose who will look after the baby. And underlying that is an assumption that the female partner in this relationship, the birth mother, is the primary caregiver. And that is an affront to human dignity. So then also they said it is further unconstitutional in that there is a difference between the number of weeks leave the birth mother gets, which is 4 months, and the number of leave that adoptive parents get, which is 10 weeks. And also employees who become parents through surrogacy. And it said there's absolutely no reason, excuse me, for making that distinction, and hence that's also unconstitutional. So the High Court agreed and set aside, well, found that the BCA is unconstitutional in these respects. It is unfairly discriminatory as between males and females, and also as against the different categories of parents. And because that is a finding of unconstitutionality, the matter had to go to the Constitutional Court in order for the court to confirm that judgment of invalidity. And then the Constitutional Court agreed, and it said, we actually need one category of leave when it comes to care and nurturing for children, and for employees who give birth, and for employees who adopt and who become parents through other ways. And all of that will now be called parental leave. And what is quite disturbing just from a pure legal perspective, I think there are two things. The first is, and I'm not arguing that parents mustn't equally share in the burden of child rearing and all of those kinds of things. But the first thing, just from a pure legal perspective, is that in the representations made by the minister said, yes, it is very clear that there is differentiation between males and females. This is discrimination because it's on a listed ground. And then said an extraordinary thing, which is this is automatically unfair because it is on a listed ground and there is no justification. That has never been the law. The law is, if there is differentiation on a listed ground, then discrimination is established. And that means that there is an affront to human dignity. Unfairness is presumed. And there is an opportunity to say, yes, this might very well be discrimination, but it is not unfair for these and these and these reasons. By stating this is automatically unfair, that goes against all the cases that we've had dealing with discrimination law so far. Equally disturbing is that the court didn't even interrogate that. The court just accepted what the minister said and said, of course, that is right. And because the court is, the minister is saying this, there is unfair discrimination, and that is the basis for granting this relief. So that I found very interesting. The second issue is that the minister, the court then read in the provisions that will apply immediately. So yes, the BCA is invalid. Who must change the law? Parliament. But in this interim period between when the court judgment was given and when Parliament will get their act together to actually change the BCA, the court wrote the sections. So that raises very interesting questions in relation to the separation of powers that I don't think we have completely gotten to grips with yet. So very interesting times ahead. In short, where there is an employee who is a single parent, that employee gets 4 months parental leave, unpaid. Of course, all of this is unpaid. Employees can go to the UIF in order to claim benefits. Very interestingly, the court didn't provide a reading in relation to the UIF. So the current position remains in respect of payments that you can get under the UIF. The entitlements are unpaid. So a single parent gets 4 months. If it is an employee who is the only employed parent in that relationship, that employee gets 4 months parental leave. So you can immediately hear it is, it may very well be a case where the other parent doesn't work because there are sufficient resources in that household. And now that individual is getting 4 months. So that raises an important question. Where both are in employment, they may decide how are they going to split this. And the entitlement is 4 months and 10 days, because the court said, we have the parental leave part, we have the maternity leave part, we put those together, and that is now the parental leave entitlement. So they can decide between the two of them how they are going to split this. Hopefully, they will have a sensible split. But if they can't agree, then the employer must apply the split. And the way in which the employer must apply the split is to be as equal as possible between the two. And that would mean 2 months and 5 days for each, depending on the circumstances. But that seems to be what the idea is. Of course, this raises an important question about the role of the employer. What proof are you going to ask for in relation to the partner who is also taking leave? How are you going to police this? Are you going to talk to the other employer? Yeah, it just becomes an administrative issue for employers that didn't exist before, and that you actually need to give very careful thought to. The birth mother still has the right to take parental leave 4 weeks before the expected date of birth, or any time before that, if that is medically indicated. And also there is a prohibition on working for a period of 6 weeks after the birth, unless a medical certificate is provided that says she's fine, she can work. Adoptive parents, so they can also share this parental leave entitlement. Again, they can agree between themselves how much they are going to take. And again, if they can't agree, then the employer needs to apply a split. So, in relation to paid maternity benefits, this has also always been a very useful attraction and retention mechanism. Employers are now considering whether they must just make parental leave unpaid for everybody. Those who can afford it can probably continue just as per usual, and they can see, how would you actually, how will it pan out in the next year or two, and then review it again. It's certainly keeping up lots of our clients at night, and yeah, there are very practical challenges. Where you do apply unpaid parental leave, a very important consideration is the contribution towards benefits, specifically medical aid scheme and retirement funding and risk benefits. Depending on the rules of the fund, it might actually be that those benefits lapse, and that you wouldn't want. So you need to think about how are you going to continue making those contributions. Are you going to require employees to do that? Are they going to agree to a deduction from their remuneration once they're back from work? Those are things that you need to consider. this is definitely something that each of you will need to consider, because most of you, by far the majority, have paid maternity leave benefits. Please call us if you need to brainstorm or to discuss this further. It isn't something that one can just, give advice to in a vacuum. It's very much dependent on your own circumstances. And yeah, we would love to hear from you. So that is now the second poll, Hels.
Perfect, Talita. And while attendees are just filling in the poll, we've got a few questions which we can just work through. The one actually just is a quick one going back to the amendments to the Code of Good Practice. And that's an observation that it was gazetted by the minister and not tabled by Parliament. And what are the legal implications of that? So sorry, just taking us back. Talita, do you have any views on that?
Yeah, that is a very interesting point that was brought to our attention about a month ago. Also, so strictly speaking, there is an argument that there are now 2 or 3 codes, if you take into account also the retrenchment code, because the Code of Good Practice that's part of the LRA is in a schedule to the LRA, and that actually requires a legislative amendment. This one was just simply published by the minister, and yeah, it is interesting. I don't think the substance of what is in the code is changing, because this is really giving effect to case law that has been delivered over the years. But it is something that the drafters are aware of, that actually when the amendments go through, they will need to repeal those schedules.
Thanks, Talita. And then just moving on to some questions from back. We may not be able to get through all of them, but I think we've got time to get through as many as we can. So the first question from Ayanda was, would we also need to consider other employer leave provisions for parental leave when both parents want to utilize this leave, but are employed by different employers? Or would it make sense for each employer to consider each employee as a single parent? I think you kind of touched on that, but just to clarify.
Yeah. No, we will need to consider, because if there's a split, the entitlement overall is 4 months and 10 days. It's not each employee that gets 4 months and 10 days. And where there is a split, that might mean that in some relationships, the female wants 3 months and the husband or partner is willing to take 1 month, or whatever the case may be. So you would need to engage with the other employer and get proper evidence from the 2 affected persons in order to actually give the leave that they are entitled to now.
And I know we've given some thought to how you do that practically in terms of the paperwork and stuff, because there's obviously a very big practical component to that. And then I think Sean's question, I think we've addressed, but if they split the leave, can each get 2 months, 5 days if both are employed? And then as Talita highlighted, that's obviously there's a 6 weeks that the birth mom, unless it's signed off, medically signed off, can't come back to work. So that's obviously going to be a consideration in how leave is split. And then, Talita, an interesting, a question I think you've also touched on, but I think a lot of employers have asked this, is if you do decide to change your leave policies where you've got paid leave to unpaid, do you need to, the one is, do you need to consult with each employee? And then the other component, another question is, will it be unfair discrimination if you just you keep your paid maternity leave policy and have the other parental leave unpaid? So I put 2 questions in one then.
Yeah, on the last one, how Section 6 of the Employment Equity Act says it is unfair discrimination for an employer in any employment policy or practice to make a distinction based on a whole range of factors, but including biological sex. So if you are saying, you know, the female employee who gives birth, that employee gets paid leave, but not the male employee, or there is a distinction in the period of leave, that may very well expose you to risk of unfair discrimination. There are ways in which one could potentially achieve that kind of outcome by, for example, giving the employees the right to choose between themselves, which is what this court judgment is all about. And they can decide, actually, the female in this relationship ought to get all the leave, and that must then be paid. Or you could potentially say, it is very important for us to attract females into our business, and therefore we are going to craft a very carefully worded and very carefully considered affirmative action measure in order to see how we can deal with this issue. This is not simple, and it is not something that has been done before, so we will need to look at that very carefully. I don't think you are going to say there are inherent requirements of jobs that require a male employee, for example, to be at work. That is going to be a difficult one. But yeah, there are ways in which one can look at this, and also, perhaps have neutral grounds on which to differentiate, which might expose you to unfair discrimination claim in that it might be indirect discrimination. But again, the facts and circumstances will need to be considered there.
And then just on the consultation point, I think our advice is always, even when it's a discretionary benefit, it is always good to consult with your employees. What form that consultation takes obviously is fairly discretionary and will depend on your workplace.
Yeah, and of course, if you have contractual entitlements, like in a collective agreement or in your employment contracts, that makes it even more difficult. So it is something that needs to be given careful thought, yeah.
And no easy path. Yeah. Just the last two questions. Just to the one question is just about whether the 4 weeks before the birth of the baby for birth mothers comes from the parental leave entitlement, even if there's a split. And Talicia, our understanding is that's correct. That would be factored into the overall leave.
Correct. Yeah. Yeah. If the wording was the remainder gets split, then it would have been different. But it isn't. It is the entitled parental leave period that gets split. And the 4 weeks before and the 6 weeks after form part of that parental leave entitlement.
And then I think that the last question I think we've got time for is someone's commented that they don't see from the judgment that the employer would need to determine an equitable split. Where is that provided for?
It is in the new section 4C. So I can just quickly find it. It is so it is in there.
It is in the judgment. And apologies, we haven't managed to get to all the questions just in the interest of time, but I think you'll have seen Bowmans has been publishing a lot on this, and in what we are going to try and do when we publish planning to put out a frequently asked questions guide, is we will try and feed as much of this in and make sure that it's covered. Talicia, just before we move on to the other cases, I think just in terms of the results of the poll, just to highlight. So for the first question was whether you plan to extend existing benefits to all categories of parents, and that was 31% of people who answered, which is interesting. So I'm reading off this. Sorry, no, that was 31%. And then the next one was we plan to extend existing benefits to all parents, but limit benefits to certain salary bands, occupational levels. That was only 5%. And the third option, we plan to reduce the extent of current benefits so that it's financially feasible to extend benefits to all categories of parents. 12%, we plan to remove paid parental leave benefits altogether, only 5%. That's good to see. I mean, we know this is only a sample poll, but I think it is indicative. We are considering legally defensible ways to retain benefits for female primary caregivers only. 0. No one's considering that, who answered. And finally, we're still unsure how to proceed and are considering our options 49%, which I think is where a lot of employers are. Thanks all. We know we spent quite a lot of time on this, but if you look at our news flashes and that, there's going to be a lot, there's going to be some more articles and stuff coming out, because it's a moving, it's a very active space, and it's thrown open so many questions. Still sticking with you, Talita, but a complete to retrenchments. So in terms of our next case law, the security force case, I mean, this is a very interesting one where it looks at reasons for dismissals and when this is, and the need for employers to interrogate this, and when it's operational requirements versus another ground. So thanks, Talita.
Sure. Yeah, this is a fascinating case, and no less because of the contractual provision that's relevant here. But yeah, Mr. Ntloleng was a security, or was a security guard, and when he signed up, he signed an employment contract and undertook to take regular polygraph tests. They were about 6 months random polygraph requirements, and also the employer reserved the right to, of course, have polygraph tests in the is an incident. This employee was at Shoprite, and there were huge shrinkage issues, and the security company then submitted, or required everyone to submit to a polygraph test. The employee failed the test. They couldn't find alternative placement for him, and he was dismissed. So off he went to the CCMA. The CCMA substantively unfair and ordered 2 months compensation. Now, this is what the contract said. The employee acknowledges that the employer's operational requirements are such that it is necessary that the employee must be completely trustworthy in the security industry. Should the employee who has been subjected to a polygraph examination not pass the examination, the employee shall forthwith be deemed to be incapable of continuing to perform work at the employer. The parties shall then enter into a consultative process where the parties shall strive to find suitable alternative, where the employee is not required to perform work of a security nature. If this is not possible, then an incapacity process will be followed. The employee hereby irrevocably agrees that the failure of a polygraph examination is a substantively fair reason as an operational requirement to embark on an incapacity process due to the impossibility of the employee to perform to the required standard set in the employment contract. Shotgun approach, boom, hey? We have incapacity, it's an operational requirement, it is substantively fair because of our operational requirements, and you are not able to perform at the standard that we require. So that one can understand that the CCMA commissioner was a bit perplexed, and he then said, listen, this was the first time that I have ever come across a clause like this. And although I was skeptical, I honestly listened to what the employer said about this. And for me, this is just not good enough. In essence, what happened here? The employee failed a test. The employee couldn't be placed at the client that the security company had the contract for because of this lack of integrity issue. That meant that the employer needed to find an alternative. When they looked for an alternative, it was in a different role for him. He couldn't be a security guard anymore. That, the commissioner said, is a typical retrenchment case. By firing this employee for incapacity, this entitled the employee to severance pay. And that is what the commissioner was worried about. This employee had 8 years service. The 2 months was actually severance pay, the 2 months of compensation. So it shows you, yes, you can have very elaborate clauses in your contract, linking all of these different reasons in some way. But come the time when you need to determine what process to follow, have a very clear understanding of what you are dealing with. Are you dealing with an incapacity, an inability to work? No. Are you dealing with clear misconduct that is proven? No, you just have an untrustworthy person. You don't know exactly what the story was there with the shrinkage. Is it a poor performance issue? Is it an ill health? No. So then it is an operational requirements dismissal. We cannot place this employee. No one is forcing us to keep someone in employment that we don't have work for. That is a structural issue, an economic reason, and then follow a fair retrenchment process and pay severance pay. So the court said the argument of the employer that the commissioner didn't apply his mind was actually not so. The commissioner's reasoning was reasonable. You could see that the commissioner grappled with this issue, and the award was upheld. So this individual got his 2 months pay, which is actually the severance pay.
Thanks, Talita. And I think, yeah, it's a good judgment to keep in mind, especially when a client says that they no longer want an individual working assigned to them for whatever reason. Ros Davies, is definitely a very familiar face, is going to take us through our next two cases, both of them dealing with unprotected strike, but with very different factual matrices. One where the employer was seen as having almost triggered the unprotected strike, and the other one relates to the involvement of a political party. Thanks, Ros.
Okay, thanks. Just checking that I was off mute. Good morning, everyone. I'm just going to change the order around, if you don't mind, and start with the case dealing with the unprotected strike. So this case is Boomerang Fruits versus Umkhonto we Sizwe political party. Now, what happened in this case is that the employer is engaged in growing, producing, and exporting fruit, or packaging and exporting fruit. They had an incident at the production area where certain employees who were entitled to receive overtime pay were paid at the incorrect rate. I think it was approximately 3 hours, and the value was relatively nominal. But this mistake was made and employees were upset. Management found out about the mistake at about 5 o'clock on a Friday, and immediately addressed the employees. So I think it was in the transport, the manager got onto the bus and said to them, "We've picked up this mistake. We will rectify it in the next day or so." So the undertaking was made to rectify it. There was no quibble about whether the amount was owed. The employer then left it. They went about sorting out their payroll issues, and the next day, no employees pitched up for work. So one of the managers went into Elgin and found that there was a picket of their employees picketing against the farm. In addition, it also became apparent that some of the picketing employees were preventing employees who wanted to go to work from getting onto their transport. The manager then went to the picketers to find out what was going on, and was told by one of the picketers that we are striking for MKP Union. He then asked for the contact details, and he was given the contact details of a representative from MKP, and the representative was apparently at the labor desk. The employees, the employer then contacted MKP, and MKP informed them that their employees had approached the political party with a number of grievances, including this issue of short payment of their overtime, but also claiming inhumane treatment, racism, and various other allegations. Now, originally, the farm was unable to speak to its employees. They weren't engaging. They were completely distancing themselves from the employer. So the employer set up a meeting with MKP to go and discuss the issues. They then sought advice, and they were told not to engage with MKP because MKP is not a union and should not be meddling in labor affairs. The farm then cancelled the meeting. This led to chaos. So the meeting was due to be held at a hotel in Elgin, and after the meeting was cancelled, a whole lot of employees and members of MKP arrived at the hotel, and they started picketing and causing disruption. I think they also disrupted traffic. So it was quite a significant issue. The police then got involved, and the police actually transported the employees to the farm where they continued to picket. Ultimately, the Boomerang agreed to meet with the MKP, and a mediation session was held at the police station. Now, the farm was represented by a legal representative who went in, and immediately the representative from MKP said, "We're not talking to lawyers. The lawyer must leave, or this meeting's not going to happen." So the lawyers then left, and the mediation proceeded. There was no resolution at this mediation. Because by this stage, although the payment was going to be made and there was no real issue on payment, there were all of these other allegations. And MKP issued a statement, a press release, saying that it was assisting employees of Boomerang to lay criminal charges against Boomerang. Now, it transpired that the criminal charges were charges of crime and injuria, which is your criminal defamation type charge. Because the strike was not coming to an end, Boomerang then approached the Labour Court for assistance. Boomerang specifically cited MKP as a party to the proceedings, and part of the relief they were seeking was that MKP be interdicted from instigating the strike. Interim relief was granted, and then the matter was set down for final relief. Now, MKP then opposed the final relief, and the basis on which they opposed the final relief was that they claimed that they were not in any way involved in the strike action, and that their role was merely advisory. So the Labour Court was called upon to consider the role of political parties in industrial relations in the labor sphere, and considered the case law, because unfortunately there has been an increasing number of incidents where political parties are getting involved in labor disputes, either because they want to keep their constituents happy or because they're wanting to attract more members and more constituents. And the Labour Court and the Labour Appeal Court have made it very clear that the role of a political party in labor affairs is limited to an advisory role only. So if their constituents go and seek advice, they can provide advice, but they are not allowed to engage as if they were a union. So the court considered this and then found that Boomerang was entitled to confirmation of the court order, because when looking at the facts holistically, it was very clear that the role that MKP was playing was not limited to an advisory role only. I mean, they They had their members and part of, included in the picket. They had slogans calling for the farm to be burnt down. They were issuing press releases, and they were the ones insisting on talking for the employees. So it became very apparent that in the mediation, MKP was the spokesperson, not the employees. So the court had no difficulty there, saying you're playing outside of your arena. You may not be involved, and ultimately ordered costs against MKP for the court action. So the lesson from that is, please, if you are finding that you've got political parties knocking on your doors, wanting to talk about employee rights, wanting to talk about temporary employment service employees and whether they should be permanent employees, be very careful before engaging. Sometimes you may need to, because it's from a practical level and a business perspective, if you can get it resolved, that might have a more beneficial position. But in the event that there is a strike and you're faced with a strike in such circumstances, cite the political party. If you can link the political party to the incident, cite the political party so that you can at least get an interdict preventing them from engaging in labor relations. Then bear with me a sec. The second case that I was going to talk on is NUMSA versus Baseline Civil Contracts. Now, I'm just going to go very, very quickly through the facts of this case. Essentially, what transpired in this case is Baseline Engineer falls within the civil engineering industry. It is bound by the collective agreement that has been extended to the industry as a whole. One of the agreed provisions or benefits in terms of the collective agreement is that all employees in the industry get a year-end bonus. Now, the collective agreement is silent as to when the year-end bonus must be paid, and ultimately says that this is when, this is how you calculate the bonus, this is what the bonus is, but doesn't say this is when it must be paid. Historically, the employer had paid the bonus sort of early December. And the reason for that was to enable employees who were sort of on leave from the middle of December when the company closed to make their arrangements for Christmas. A lot of them would be going away on holiday, and so that they'd have that bonus to assist with that. What they discovered in the previous 2 years is that there was a huge amount of absenteeism in the weeks leading up to the shutdown. So unauthorized absenteeism. Now, generally, when there's unauthorized absenteeism, they would then take it from the bonus. It would be deducted from the bonus in terms of the calculation. But because there wasn't time for the employer to do this calculation, they were paying more in respect to the year-end bonus than they would otherwise have been required to pay. Decision was then taken, they were going to pay this bonus on the 23rd of December. So after the holiday started, but just before Christmas. This decision was taken in early December. It was, the employees were notified of the decision on about the 8th of December, and the employees embarked on an unprotected strike the next day. Throughout the day of the strike, the employees were given ultimata. I think 4 ultimata were given, one at 8 o'clock, one at 10 o'clock, one at 3 o'clock, and one at 4 o'clock. Each of the ultimata gave the employees 1 hour to return to work, and then the final ultimatum said, you must come to work tomorrow morning. So it was a call for them to resume their normal duties the next day. The employees were still dissatisfied because although the company had said, look, what we'll do about this year-end bonus, we'll meet you halfway. We'll pay 50% of the bonus, sort of mid-December when we used to pay, and we'll pay the balance on the 23rd of December. The employees weren't happy with this, and they wanted the full bonus in accordance with the common practice. The employees did not return to work in accordance with that fourth ultimatum on the following day, which was a Saturday. The next day was a Sunday, there was no work, and they didn't report to work on the Monday. The day after that was the 14th, and it was an early shutdown at that stage. In the meantime, the employer had also reached out to the union to ask for their assistance, asked to engage with the strike. The union took about a day and a half before they responded, and ultimately came and said, look, we'll have a meeting with you at 9 o'clock on the 14th of December. The company said, that's too late. There's no point in having the meeting because we shut our doors at 12 o'clock on the 14th. So, then the strike comes to an end anyway. So no meeting was held, and ultimately no agreement was reached. And in the long run, I think the employees were paid on the 23rd of December. Operations resumed on the 10th of January. And at that stage, the employer said, the employer suspended all of these striking employees. So they were suspended, and they were issued with notices to attend a disciplinary inquiry to be held on the 13th of January. An external chairperson was appointed, and in considering the case, the external chairperson looked at the fact that it was an unprotected strike. I think there was a loss of about 6 million rand as a result of the unprotected strike. There was reputational damage because the employer was unable to meet its contractual obligations because of the early shutdown. And so there was contractual obligations that it just didn't meet. And then ultimata had been issued. So the chairperson also considered the fact that the employees were responding to the conduct of the employer in changing this date. But he was of the view that their conduct was out of proportion to the complaint, and that they could have actually dealt with the complaint in other ways without resorting to an unprotected strike. The matter then went to court, and the court, it's clear, the court accepts that participation in an unprotected strike is serious misconduct. That's not in dispute. It's something that and the reason for that is unprotected strike action is aimed at causing damage to the employment relationship. But the court said that doesn't mean that dismissal is appropriate for each and every instance of unprotected industrial action. And what the court said is you've got to look at everything holistically, and you've got to look at the entire process throughout. And ultimately the court said, well, it's something we know already. Issue ultimatums. You must have ultimatums issued before you want to dismiss. So in this case, the ultimatums were there. Looks at the duration of the strike. How long was the strike? Was it a 3-hour strike? Was it a 3-day strike? Because that's obviously relevant to the amount of damage. The actual damage suffered, conduct during the strike, and then what was the cause of the strike? And the court, it's tried that where an employer commits unlawful conduct, an employee embark on an unprotected strike, in response, a dismissal is unlikely to be found to be fair because it's a reaction to unlawful conduct. But the court went further and confirmed that where the strike is in response to unjustified, unreasonable, or unfair conduct, then this is a compelling reason to find that dismissal is not appropriate in the circumstances. And that's what the court found here, was that the conduct of the employer in pretty much at the last minute, changing the payment date, where they had a practice for years where they paid it sort of mid-December, had significant impact on employees because it impacted on their ability to pay for their transport to go on holiday, to buy anything they needed for the holiday, for the Christmas period, etc. So the court was satisfied that in these circumstances, the dismissal was inappropriate and they should have received final written warnings. So employees were then reinstated. Lesson from this is, if you are faced with an unprotected strike, you need to look at everything holistically, and you need to seriously consider what was the reason for the strike, because if it is a response to some form of unfair or perceived unfair conduct by the employer, even though in this case there was a good rationale for the employer's decision, it doesn't necessarily mean it was fair, and you need to look at past practices. So yeah, those are the takeaways from that case. Thanks, Helen. Back to you.
Thanks, Rose. Thanks. Our next two cases, Luwe Mongi is going to take us through, both dealing with misconduct. I know, Luwe, the first one is something close to your heart. You've been doing lots of work on the weaponizing of whistleblowing. I'm not sure that this case falls in that category, but it does deal with Section 188 inquiries in terms of the Labour Relations Act. And then the second one is also very interesting, dealing with the principle of double jeopardy and just how many bites of the cherry does the employer have. Thanks, Luwe.
Thank you, Helen. So, Helen, as you mentioned, the first case deals with Section 188A inquiries, and I think it's quite useful just very quickly at the outset to mention what these are. I don't think it's a process parties and employers in particular, understandably reluctant. So what that envisages is where, for example, a disciplinary process is being undertaken, the parties can agree that the inquiry in terms of that process can be heard before the CCMA rather than running that process internally. And that requires the consent of both parties. But what this case deals with and what we are seeing a rise of is subsection 11 of that provision. And it provides that if an employee alleges in good faith that the holding of an inquiry contravenes the Protected Disclosures Act, that employee or the employer may require that the inquiry be conducted in terms of this section, so before the CCMA. And so what that then changes is that actually, and what this case, and I'll speak through the case, suggests is that the employee under those circumstances won't necessarily require the consent of the employer. And why we're seeing an increase in it is that, and some of the case law speaks to the potential abuse of this provision, and that employees may, perhaps in bad faith, try to refer the matter to the CCMA under those circumstances. But that's not the instance in this case. So I think this case is very helpful in just discussing what the principles are that apply in those instances. So in this instance, the employee was employed as a provincial manager for the employer, and there was an AG report in which it was flagged that there'd been potentially some concerning transaction between the employer and a contractor. So the concern didn't go into a lot of detail, but the AG essentially identified a potential impairment of the independence involving the chairperson of the employer's audit and risk committee, and also he was a director of the contractor. Now, despite this red flag, the employer then subsequently paid the contractor 655,000 Rand that had been invoiced to it. And this information, an invoice and the proof of payment then came to the employee's attention. And he emailed it then to his private email account to preserve the evidence. He thereafter met with his attorney and they discussed this. He provided the invoice and the proof of payment. And there was this concern that this was potentially fraudulent. Now, thereafter, about just over a month thereafter, the employer then issued the employee with the first notice of disciplinary allegations. And these alleged that he had emailed this confidential information to his personal email address and disclosed such information to the media. At this point, no hearing date was provided. And then about 5 months later, in March, earlier this year, the employer then replaced the initial charges with the second notice. And the employee was given a fresh set of notices, but of allegations, but essentially the allegations were that he breached his employment contract and the code of conduct and acted in bad faith, linking that to providing the Sunday Times potentially with this information. The employee's attorneys then wrote to the employer and stated that they wanted to exercise their right in terms of Section 188A11, and that the matter should not be dealt with internally, but rather that the matter should proceed before the CCMA. And the employer then said, well, they're not going to agree to that, and that the matter will proceed in terms of this process. The employee then made representations to the chairperson, and the chairperson ruled against the employee, saying that it won't proceed in terms of Section 188A11, and that the matter will proceed, and they set down a date on the 2nd of July. What then happened was that the employee then proceeded to apply to the Labour Court on an urgent basis, seeking to interdict these proceedings. And the court looked at the matter and broke down essentially what the principles are that applies in this instance. So the first thing that the court looked at was whether a protected disclosure had been made in terms of the Protected Disclosures Act. And it said that it seemed that the employee had reasonably believed that a criminal offence had been committed or may be committed, and therefore had approached his attorneys on that basis and disclosed this to them. So the first question was whether there was a disclosure. The court was satisfied a disclosure had been made. And then the second aspect to it was whether it was a protected disclosure, which requires a number of facets, but essentially in this instance, it was made in good faith, and it was through a channel that is recognized for whistleblowing of this nature. So it was satisfied a protected disclosure had been made. The next principle that then needs to be applied is the nexus between the protected disclosure and whether, as a result of that, an occupational detriment was being caused. And in essence, that looks at whether they believe, the court will look at whether, in a sense, there's retaliation. So protected disclosure has been made, and then the employer is taking action on account of that. And the court again was satisfied that this was the case. The court had to remain vigilant to the possibility of retaliation under these circumstances. And in its mind, the disciplinary hearing therefore constituted an occupational detriment, and there was a sufficient nexus under these circumstances. And then the court said that under these circumstances, if the employee then wants to rely on Section 188A11, that then at that point becomes effectively a unilateral decision from the employee standpoint. And once invoked in good faith, the internal disciplinary process should then fall away, and the matter will then proceed before the CCMA. So under these circumstances, the employee was successful, and the court did interdict the disciplinary proceedings, and the matter was required to proceed before the CCMA. And so, as I mentioned, we are seeing a rise of this kind of process. It is open to abuse. So, for example, what we are seeing is that employees may be under investigation or subject to poor performance measures, for example, and then shortly thereafter, they will then issue a document to the relevant body and say that there's a protected disclosure being made, and then seeks to invoke these provisions. That factual nexus is, of course, different to this, but we are seeing matters of this nature. So I think it's a very interesting case and something that employers will need to be mindful of. Then just moving on to...
Just before you move,
sorry, yeah,
apologies,
sure.
before you move to the next one, I think we're also seeing that companies are actually reviewing their whistleblowing policies and related policies, because in some cases they've cast them so wide in terms of what constitutes whistleblowing. So it's been quite interesting over the last year or so, and I know you've been doing a lot of work in this space, Luay, but re-looking at that and that policy framework.
Correct, Helen. Just very quickly on that, what we have noted is that, of course, it's very important that whistleblowers play a very critical role in obviously for employers and corporate South Africa generally. But what has evolved as part of that process is this, we've tried to allow for anonymous whistleblowing, and that has become too wide. So perhaps in the interest of protecting the whistleblower, we've sometimes spread what can be reported anonymously beyond what was actually envisaged as what can be reported anonymously. And we're seeing that, for example, things like bullying and things of that nature sometimes is also permitted to be reported anonymously. And so we've been reviewing that kind of and advising on that kind of processes for employers. But yeah, it's a very interesting space at the moment. So then just moving to the second matter, also very interesting factual nexus. In this instance, the employee was employed by a municipality, and there was an investigation. He was employed as a permanent accountant in the finance department, and the bankers at the municipality flagged potential fraudulent activity related to their bank account. This prompted a forensic investigation, and the inquiry revealed that various and several unsuccessful attempts had been made from his computer, from his workstation, to access their CashFocus internet banking portal, of course, which belonged to the municipality. Now, the investigation didn't in itself establish who had operated the workstation at the relevant time. And so the municipality then instituted allegations against the employee. He was called to make representations, and the allegations were essentially that he had failed to conduct himself with honesty and integrity, alternatively fraud, premised on an allegation that he'd attempted to access the bank account without authorization. And in the internal disciplinary process, he was found guilty and dismissed. The employee then approached the CCMA challenging his dismissal. And what emerged during those proceedings was that the employee and a colleague's passwords had been written on their desk calendars, and that even auditors had accessed his computer using those passwords. And so ultimately, the CCMA found that the employer couldn't establish on a balance of probabilities that it was the employee that had accessed the finance options, the account of the municipality, and therefore found that the dismissal was unfair. However, quite significantly in terms of remedy, the commissioner criticized the employee for irresponsibly allowing this access to his computer by writing these passwords on his calendar. And this was contrary to their IT policy. So the arbitrator then held that his hands are not clean and exercised a remedial discretion and instead ordered that instead of being fully retrospective reinstatement with back pay, the employee would be reinstated, but the period of 4 months that had passed during that period should be treated as unpaid suspension. So in effect, a lesser form of misconduct of negligent password handling was found to be appropriate by the commissioner, and he received the sanction. Then the employer, the municipality, thereafter approached the Labour Court to take that on review, and they were unsuccessful with that review. And the employee was thereafter reinstated by the municipality. Now, very interestingly, a couple of weeks thereafter, the municipality then convened a second disciplinary process against the employee and stated that based on the gross dishonesty and failure to comply with the IT procedures by sharing the password, the employee had exposed the municipality to risk of fraudulent activity. The employee was found guilty of this and then dismissed a second time. This matter then went to, again, on review from the employee to the Labour Court, and the Labour Court upheld the dismissal, saying that the second disciplinary charges were completely new charges which emanate from the same facts, and that the sharing of a password amounted to gross dishonesty, which undermined the trust relationship. The employee then applied, well, this was then, sorry, that was before the CCMA. The matter then went to on review, and on review, the court agreed and stated that this was an instance of a second disciplinary process, but that under these circumstances, new facts had emerged during the proceedings, and therefore it was warranted. This then went on appeal to the Labour Appeal Court. So the court found that the dismissal was fair. And the Labour Appeal Court first looked at this concept of, sometimes we refer to it in criminal law as double jeopardy, and it sometimes finds its way into employment circles. But essentially, this idea of having a second disciplinary process for an employee. And the court confirmed what the case law has said over time. Of course, there has been a little bit of uncertainty, but in essence, the principle is that if it's fair under the circumstances, then an employer can proceed with a second disciplinary process. They said that usually this would require that exceptional circumstances are apparent. So, for example, if new information comes to light, or if the initial process was materially flawed. But in essence, the court again confirmed that it is possible, but it must be fair under the circumstances. But what the Labour Appeal Court then said was, however, what the previous tribunal had overlooked was that there was this binding arbitration award from the first instance, which had stated that the employee was found guilty of this lesser offense of negligent password usage, and had applied a sanction by applying the unpaid suspension of 4 months, and said that the Labour Court had overlooked that, and as had the CCMA. And under those circumstances, the employee had already been sanctioned for essentially the same misconduct, and that under those circumstances, the employee cannot be subjected to the second disciplinary process, because that arbitration award was still binding and of legal effect, and had not been overturned on review. And because of that, this disciplinary process emanating from the same set of facts for which he was found guilty by the CCMA in the first instance still applied. And therefore, under those circumstances, the employee's dismissal was found to be unfair. They said that this amounted to a second sanction for the same set of facts, and therefore that couldn't be upheld, and the employee was reinstated.
Thanks, Chloe. You can only imagine how awkward that relationship must have been after that history.
Yeah, I think it's just very important that you know the investigation process and both the disciplinary allegations under these circumstances must just be so very carefully considered, so that one doesn't find oneself in this situation. Thank you, Helen.
Exactly, and we know that on that double jeopardy, it's only in exceptional circumstances that you can apply it, and this clearly wasn't that. Thanks, Louay. We are handing over to Melissa Coggan now. We're going to stick to misconduct. Both of the cases that Melissa is going to take us through bizarrely involve cough syrup and failed breathalyzer tests, but with very different outcomes. Thanks, Melissa.
Thanks, Helen, and good morning, everyone. So the first case that I'm going to discuss is Chilled Beverages International versus the CCMA. In that case, Mr. Tsetsami was employed by Chilled Beverages, and that is a manufacturer and distributor of beverages. And his job was a forklift driver, and it involved transporting raw materials, which included heavy bags of sugar and containers of up to 1,000 liters of liquid ingredients. Because he tested positive in a breathalyzer test for alcohol, he was dismissed for gross misconduct, and the employer's alcohol, drug, and substance abuse policy prohibited employees from having any intoxicating substances in their bloodstream during working hours, and forbids them from using alcohol during work or within 6 hours before the start of their shift. It had a zero tolerance clause relating to alcohol in the bloodstream, and all employees were subjected to a breathalyzer test when entering and exiting the factory. So Mr. Tsetsami tested positive for alcohol after he had arrived to work an hour late, and he was required to undergo several tests using different devices to ensure that the initial device wasn't faulty. He was also given an opportunity to eat and drink before being retested, but the test results remained positive. His reason for failing the breathalyzer test was that he had taken medicine the evening before, and on the morning of his shift. And he said that he hadn't consumed any alcohol, and he was not aware that the cough syrup contained alcohol, and he had not read the label. He then took his unfair dismissal dispute to the CCMA, and he claimed that the dismissal was substantively unfair. He admitted that he was aware of the policy, and he admitted that there was alcohol in his blood, which resulted in him failing the breathalyzer test, but he maintained that he unknowingly contravened this policy and that dismissal was not the appropriate sanction. In line with the employer's policy, which required each case to be assessed on its own merit, the commissioner in that case took into account the nature of his role, the risk to the work environment, and his service record. And he found that in relation to the surrounding circumstances, there was no other evidence to suggest that he had consumed alcohol before or on the morning of his shift. So he hadn't shown any signs of intoxication, and that was not in dispute. And the employer also didn't dispute the fact that he had consumed cough mixture, and he had a clean disciplinary record. In addition to that, the commissioner found that he was a credible witness. So he took into account all of these various factors, including the fact that other than, alcohol in the form of spirits and beer and wine, there are other types of medication that could potentially trigger a positive test result on a breathalyzer, including cough mixtures. So taking all of those factors into account, the CCMA commissioner found that his dismissal was substantively fair. But the employer was unhappy with this and took it on review to the Labour Court. But the Labour Court found favour with the CCMA commissioner. It said that all of the material facts were common cause, including the fact that he hadn't shown any signs of intoxication, and he hadn't been working whilst intoxicated. And the court said that a zero tolerance policy could be fair if the circumstances necessitate its implementation by the employer, but the employer still has to show that dismissal is an appropriate sanction and proportionate to the misconduct committed. So despite a zero tolerance rule, the sanction of dismissal in that case was inappropriate, and also found relevant the fact that he had a clean disciplinary record and his appearance and conduct didn't indicate that he had been consuming alcohol. So the award was found to be reasonable and fair, and the review application was dismissed. So in line with previous case law, this case confirms that even though you can have a zero tolerance policy, and that may be necessary in certain circumstances, taking into account the nature of the work and the operations involved, the health and safety risks involved in relation to operating heavy machinery, there's still an obligation to make sure that the sanction is appropriate and proportional to the misconduct involved, as well as all of the relevant surrounding circumstances regarding the alleged misconduct. So be cautious about relying on a breathalyzer test alone. Take into account whether there's any other factors that might indicate this person's faculties are impaired physically or mentally, and then interrogate the circumstances around which you apply that zero tolerance policy. Then we have a case with a different outcome, which is Mtsitshana versus CCMA and others. This was handed down in September this year. And in this case, the applicant was employed by a mining company, and she was found dismissed after having been found guilty of misconduct for breach of the employer's alcohol policy. She denied as well that she had breached any rule or standard, because she claims that on that day she had consumed Alcophyllex cough syrup. I don't know the brand. which contains alcohol. And she said that she had reported this to the person that administered the breathalyzer test. But that fact was in dispute in terms of the timing she disclosed that fact. So the security guard that was on duty that evening, because it was a night shift, was called to give evidence in the proceedings. And her responsibilities included the administration of these breathalyzer tests and alcohol screening of all persons that were entering the mine. And she was aware that there was a general rule in this workplace that a person who had tested positive and had alcohol in their system should not be permitted to enter the mine. Obviously, because of the nature of the workplace and the type of machinery involved and the high risk it is to employees on the premises and others, the employer consistently maintained that policy. So prior to administering the breathalyzer test, she checked that the breathalyzer was properly calibrated, and then she also administered 2 tests within 20-minute intervals with the applicant. So the first test was administered at about 20 to 9 in the evening, and she used a specific type of rapid test machine, which played a sound when alcohol was found present in the applicant's system. And then she invited the applicant to come into the guardhouse to wait while she administered a second test, and gave her 20 minutes between the 2 tests in accordance with the employer's policy, and also used a different machine just to make sure that there wasn't a misreading on the first machine. The conduct of the employee in question in that 20-minute period was considered relevant by the commissioner, and she was getting quite agitated. She said she needed drinking water because she was sweating and dehydrated. She couldn't wait 20 minutes for the next test to be administered. And the security guard informed her that she was not permitted to consume any liquids between the 20-minute waiting period, as that would impact the results. Regardless of that instruction, she then consumed a Tropica drink and had a grandpa because she had a headache. And then she requested to go to the bathroom 3 times within the 20-minute period. The security guard then administered the second test and used a different machine, and the reading was still positive. The supervisor on duty was then required to complete a sensory evidence checklist. So this looks at the mannerism and the way in which the individual is acting to further corroborate the findings of the breathalyzer test. And his checklist also indicated that she was becoming aggressive and that her behavior was unorthodox. So she was then requested to exit the mine, and the security guard said that only at that point did the applicant say that she had taken a cough syrup just before her shift. But she didn't produce that bottle of medication or give any other evidence related to that. And the security guard also said that she smelled of alcohol and alcohol smelt on her breath. And then the applicant said she had consumed alcohol the previous day. So all of these representations were a little bit late and after the fact, obviously in a flurry. And I think these factors are relevant because the outcome here is different to the previous case that I've taken you through. The employer's human resources coordinator was then also called as a witness, and he spoke about the zero tolerance policy, the rule that had been imposed, and highly relevant to this case was the fact that this particular employee had actually been disciplined for breaching the alcohol policy in 2019. And she had been given a final written warning for that misconduct, and she had been referred to the employee assistance program offered by the employer. The policy as well also recognized progressive discipline. So for a first offense, a final written warning was permissible, but if an employee was found to have breached the same rule, the second offense would justify dismissal in that case. The applicant then at the hearing presented a medical certificate claiming that she had taken flu medication, and that was the reason why she was also taking cough medicine. And she said it was unfair that this previously wasn't requested of her. And then she again denied that she hadn't taken any alcohol. She admitted that she'd been previously disciplined for consuming alcohol, but she claimed that this warning had expired by the time this disciplinary inquiry had taken place in March 2022. The commissioner found that the dismissal was substantively fair. And the applicant then took the matter on review to the Labour Court and alleged various grounds of review, mainly for reasons that the commissioner had disregarded material evidence that was before him. For example, he didn't place much weight on the fact that there was a medical certificate and that there was flu medication that she had taken the previous day. The Labour Court said that it was common cause that she had tested for alcohol, that she had been previously disciplined for testing positive for alcohol, and the sensory evidentiary checklist indicated that there were other factors showing that she had consumed more than what we would consider normal for consuming cough syrup. And even though the first written warning had expired by the time she was charged, it was similar misconduct and it was still relevant at the time. So just because it expires doesn't mean that the employer can't take it into account in determining what the appropriate sanction is. In this case, the court also said that there was a zero tolerance policy. It looked at the various case authority regarding zero tolerance policies and the applicable principles, and said, in line with other cases, that zero tolerance policies can be accepted depending on the circumstances of the particular case. And that includes taking into account the nature of the workplace, the operations involved, and whether there's any machinery or dangerous equipment that has to be used. So it's not a case of applying a zero tolerance policy, and as soon as someone breaches it, it's always going to result in dismissal. But in this particular case, the court was convinced that it was an appropriate sanction. And in that case, the court did not find that the commissioner was unreasonable in finding that dismissal was substantively fair. It looked at the various principles in terms of, misconduct related dismissals, which looks at the importance of the rule that's breached, the reason why a sanction is imposed, why the employee challenges the dismissal, what the harm is or the potential harm caused by the conduct, whether additional training or instruction could potentially prevent this in a particular employee going forward in terms of repeating the misconduct, the previous record of the employee, the effective dismissal on the employee, and if they have a long service. So taking into account all of those factors and the evidence in its totality, it found that the decision the applicant was dismissed fairly was one that a reasonable decision maker could make. So a key takeaway from this case is that there may be cases where it is appropriate to dismiss for a breach of a zero tolerance policy. But when you compare it to the previous case, it's always going to be subject to the particular facts of the case, and be very wary of relying on just the results of a breathalyzer test alone, because there are false positives that can.
Thanks, Melissa. I'm sorry if I'm cutting you off, but your screen's just frozen a bit. And I just, one observation for me is I think that if you look at the two cases Roz took us through in terms of the strike cases,
is a workplace different if it was an administrative type of role.
Thanks, Melissa. Apologies. I hope for the rest of you I wasn't speaking over Melissa first, but I'm just saying in terms of, I think one of the underlying themes that has come out of the cases today before we move into our last two cases is that we are really a fairness-based employment system. I know that sounds so obvious, but it's the same principles that apply to the strike cases apply to the breathalyzer test, in that it's always a fairness-based test, looking at all the factors, as opposed to kind of a hard and fast X will always equal a dismissal. Komotso, you've been very patient, and you're going to take us home with our next two cases. Komotso's the first one. The Samu case is going to look at how stringently you need to apply the Code of Good Practice, which Talita started off discussing. And then the final case, it will end off, the Bombela case relates to unfair labor practices relating to suspension. Thanks, Komotso.
Thanks, Helen, and good morning, everyone. So I'm gonna be brief. I can see people need their coffee. So this case, quite sadly, is an old case. So the employee in this case was dismissed back in 2017. It was heard by the Labour Court in November last year, and the Labour Court delivered their judgment on the 10th of October this year. So I'm mentioning those facts because sometimes when you look at the principles, we also forget just how long matters take to be completed, at least to make it to the Labour Court. So the facts of this case really are very brief. The Mvinjelwa was a shop steward and a local office bearer for SAMU. And he worked in the licensing department of the city of Tshwane. I won't tell you which branch in particular so that you don't boycott it. So he was alleged to have slapped a member of the public after some confrontation. In particular, this member of the public stated that they had waited for hours in line to be assisted. And when they went to his cubicle, he told them that he can't help them without an original ID. He needed an original ID, not a certified copy. And because they'd waited for so long, so it was two ladies, the complainant had accompanied her sister to the licensing department to renew her license. And I think in total, they waited about 6 hours before they could be assisted, or they were told they can't be helped because they don't have the original copy. So seemingly, when the employee insisted not to assist them, the sister then uttered as she left that this is effed up. The employee then went from outside of his cubicle, went around and slapped this member of the public on her face. So this fact was denied. So the complainant indicated that this was in open view of other employees and other members of the public. As you can imagine, the setup in the licensing department. And she says that there were two police officers who were wearing plain clothes who came to her rescue, rescued her from further being assaulted by the employee. The employee's stance was that he was insulted by the complainant, but that he did not slap her. And at the arbitration hearing, which we'll come to in a moment, he called one witness, and we'll talk about what that evidence was. But at the disciplinary hearing, the employee did not at any point complain about the notice, which as we all know, the employer has to give to the union. And he was represented by the union at both the disciplinary hearing and also at the arbitration stage. What the employer had done, however, was they issued the notice to the union on the same day that the hearing was supposed to take place. But for some reason, that hearing did not take place and it was postponed. And there was a period of about 5 months between when the notice was now given to the union and when the hearing actually took place in July. But as I indicated, at the disciplinary hearing, where the employee was dismissed, the union did not take issue with notification and lack of consultation as required in terms of item 4.2 of the Code of Good Practice. So when this matter then went to the CCMA, the essential controversy before the commissioner in terms of procedure was whether or not the dismissal was procedurally fair because the employer failed to consult with the union. So in other words, the union contended that the notice that was given to them was late. It was only saved by a postponement. And in that period of the postponement, the employer took no active steps to try and consult with the union. So in relation to the substantive fairness, the union, on behalf of the employee, called one colleague who sat next to the employee, whose testimony simply was that, look, I just had the employee standing up and going around the cubicle saying, who do you call an F? And she didn't see anyone being slapped because her view was obstructed. And also she did not hear what the complainant had said to the employee. So that was the best evidence that the employee furnished at the arbitration stage. The complainant, the employer at the arbitration called both the complainant and her sister, who corroborated each other. And the evidence remained the same, that the complainant said, this is effed up, as she left, because they were the employee was refusing to assist them, and that the employee then came around to slap on her face, and that she was rescued by these two policemen. The employer, the union rep, in putting some questions to the complainant, did say at some point that the complainant will come and say that he did slap you, but it was because you obviously insulted him. But obviously, when the employee came to testify, he denied this. He said he did not give that instruction to the union official, but also that he did not at any point slap anyone on that day. How the arbitrator resolved this issue was simply to find, in relation to the substantive fairness, that the two employees' evidence corroborated each other on behalf of the employer, and he was satisfied that absent any other evidence supporting the version of the employee, that on a balance of probabilities, the employee did slap the complainant, and that the employee's version is made up and opportunistic at best. He also, in relation to procedural fairness, found that there was sufficient attempt by the employer to consult with the union, although there was no consultation, and that notice had been given, and that the postponement also, because it was for such a prolonged period of time, provided an opportunity for the parties to consult if they needed to do so. So the employee, obviously, and some were not happy, and took this matter on review to the Labour Court. And the judge, in essence, in dealing with the code, as Helen stated at the top, said that we must not forget that the code is supposed to be a guideline and not supposed to be a stringent requirement. And therefore, some level of compliance in certain circumstances may be accepted. And in this instance, the court was satisfied that the union were provided with a notice of the disciplinary hearing and asked to consult, and that it was not incumbent upon the employer then to take any further active steps to ensure that that consultation takes place. The judge was also satisfied that at the disciplinary hearing, the union had an opportunity to raise this issue as well, if indeed there was real prejudice, but that was not done. And that even though the union cited an authority that an arbitration is a hearing de novo, and therefore even though this issue was not raised at the disciplinary hearing, they are entitled to raise it at the arbitration. the judge acknowledging that said he is still satisfied that even if we looked at an arbitration as a hearing de novo, in considering the question of prejudice and sufficient consultation or notice, he was satisfied that was done. And therefore, it was not necessary for the employer to have done anything more in order to fulfill the requirements of Schedule 8, Item 4.2. In relation to the substance, what the union had done was to complain really about the evidence that the two policemen came to the rescue of the complainant. They stated that that is hearsay evidence. I mean, I don't need to spend time on that to say it was not. And that is what the judge found, that what they were stating was direct evidence, and that calling those two police officials would have served only to corroborate their evidence, and that was not required or necessary, or it does not affect the fair assessment of whether or not the versions of the two witnesses ought to be believed, and therefore there was no basis to overturn the award, at least on the basis of substantive fairness. The other reason that the union advanced for substantive fairness was that the employee had not obtained a J88 form. In other words, had not gone to the doctor to complete a form that indicated that there was harm done to her. And the judge equally was satisfied that that is not a requirement and it is not necessary in this instance for the purposes of a disciplinary hearing and therefore an arbitration process, that a J88 is obtained. And in an event, he again said, if it was obtained, that would have just corroborated the evidence that they were able to give competently and directly to him. And really, that is just the case as a reminder that although it is required in terms of the code that the union has to be informed prior to disciplinary action being taken against a shop steward, which obviously is to prevent victimization of shop stewards who are doing their work in terms of representation, but that we should always remember that the code is a guide. It is not required to be complied to strictly. There must still be some level of compliance, but that at any given point in time, the circumstances of each case will have to be assessed in concluding whether or not there was procedural fairness or unfairness. And in this instance, the court was satisfied that the employer in this instance took the necessary steps to inform the union. It would have been consent, the judge had said, if it were that the hearing proceeded on the day when the notice was issued, but that it was postponed and for 5 months, that was a telling factor for the court, which then tilted the judge's decision or view that there was procedural fairness. So this just made me to think, Helen, that we need, and I think this has now been a new song, right? That we need to revisit our policies to see how stringent they are and to see how flexible those policies are in how we comply, I guess, with the code and the different codes, whether we're dealing with misconduct or other aspects. I think it is important that we align our policies to this line of thinking and not create problems for ourselves in that regard. So that is the first case, and I think the last case very quickly. So this involves a suspension, and it is a case between Bombela and Letlhokwa. I think it is important to mention at the top that the matter that went to the Labour Court involved the unfair labour practice as a result of a suspension, but Letlhokwa was dismissed. So the facts of this matter are that Letlhokwa again was an office bearer and a shop steward, and he was presented with a suspension letter just immediately after finishing his shift. So he was not given the opportunity to make any representations as to why he should not be suspended. And when this happened, the employer had not informed or notified the union of the impending suspension. The reason why Letlhokwa was suspended was because of allegations that he had disseminated confidential information belonging to the company to third parties. So the company needs notice indicated that the reason for the suspension is to allow for a fair and open investigation, and that he would not interfere with that process. The union wrote to the employer a number of times complaining about this, saying it is a disciplinary sanction and they ought to have been informed, as is required in terms of item 4.2 of the Code of Good Practice. And the employer insisted that that was not necessary in the premises. As I indicated, the suspension lasted for a month, and it was paid suspension, fully paid suspension, and the employee was dismissed in that period, in that process. So before he was dismissed, however, he had referred an unfair labor practice dispute to the CCMA relating to suspension. At the time when the arbitration said, as I indicated, the employee had been dismissed, was the issue of suspension. Important in this case is that the company had a code, the disciplinary code, which was not a collective agreement, and I think that fact is important to mention. And I just want to read out 3 clauses from that code that speaks about suspension, because it is what this case turned on later on. So it is clause 5.6. I mean, it is titled suspension, and it's in 5.6.1. It says an employee may be suspended on full pay pending the disciplinary hearing if circumstances are such that the employment relationship or the relationship between the employees or the disciplinary process could be harmed by the presence of the employee on company premises. 5.6.2, such suspension does not form party, I think it's supposed to mean part, of the disciplinary sanction and is merely implemented as a temporary measure. 5.6.3, the employee should be given an opportunity to make representations should he or she wish to challenge the suspension. The presentation made by the employee, if any, must be taken into account by the manager prior to the decision being taken to suspend the employee. So the union argued at the arbitration that irrespective of the fact that at this point in time, the Constitutional Court had made its decision in the Long case, that this company code and procedure still was applicable because it had not been amended, and therefore the expectation in line with 5.6 was that the employer was required before suspension to inform the union of the decision taken by the company to discipline the employee. So very critical, it was not the union's case that the employee should be given an opportunity, or indeed that he wishes to take up an opportunity to make representations, but it was solely in line with item 4.2 that they were supposed to be informed before the company take disciplinary action against the employee. The company contended that in terms of process, that they were precluded by the Long case, which had found that in a precautionary suspension scenario, there was no longer a requirement for representation to be sought before a decision is made to suspend, provided that suspension is with pay, as there would be no prejudice or minimal prejudice to the affected employee. And therefore, it then argued that that suspended the operation of its own code, even though they had not amended that code at the time. Of course, as I indicated earlier, in terms of the letter of suspension, the notice of suspension did indicate that the reason for it was because the employee was a union shop steward, and they were concerned that he might interfere with the investigation, and also that because of his position, he had influence, and he might influence negatively the work environment. The commissioner found, in respect of procedural fairness, that the suspension was procedurally unfair, she found that long did not apply. Sorry, one thing to mention is all the 3 witnesses who came to testify, 2 for the employee, 1 for the company, all really gave evidence interpreting this clause 5.6 and whether long applied. So the commissioner's view was that you just presented arguments to me and not evidence in respect of the facts, because I guess the facts were largely common cause. So the commissioner found that the procedure was unfair that was followed, because even though long was the prevailing law at the time, the employer had not taken up the opportunity to amend its code, and therefore, in terms of the code, the employer was required to give the employee an opportunity to make representations before the suspension. She also found, the commissioner, that in terms of substance, the employer needed to go further than simply aver that there is a pending investigation, and ought to have actually investigated and provided reasons to justify that indeed the employee had the propensity or could have interfered with that investigation. At the Labour Court, the judge, by and large, agreed with the commissioner on both reasonings, but not in terms of the outcome. In relation to the process, the judge said it is correct that when courts make rulings or give decisions, that those decisions do not automatically nullify internal company codes or collective agreements, and that the employers had the duty or the obligation to do so, to change them, particularly if those codes do not provide for rights that are less than what the court would have ruled at the time. So in this instance, the judge was of the view that even though Long had indicated that there was no longer a requirement to make representations, he was satisfied that the commissioner was right, that the employer could not hide behind that decision in not having afforded the employee an opportunity to make representation. However, the judge disagreed with the commissioner in respect of clause 5.6.3, which I read earlier. He said that the commissioner could not correctly conclude that the employee was not given an opportunity to make representations, because the code itself says it was up to the employee to request or to indicate an interest, a desire to make this representation. I'll read 5.6.3 again just at this juncture. It says the employee should be given an opportunity to make representations should he or she wish to challenge the suspension. And the judge said this was not taken up at any stage. Instead, what the union misconstrued was that this was actually a disciplinary sanction when it was a precautionary suspension, which is different. And therefore, they made arguments in respect of being notified in terms of item 4.2 and did not use the provisions of this code. So as a result, on that basis, the judge found that there was procedural fairness because the employee failed to take up the opportunity to make representations, and that in this instance, the employer could not be faulted despite wrongfully relying on Long as a basis. He also said it would be conjecture to try and argue that if the employee had taken up this opportunity, the employer would not have considered those representations anyway because of their reliance on Long. He said we can't go there because that was not the case, and that was not what was before the commissioner. And in terms of substance, quickly, the judge found that although he agrees or can't blame the commissioner for coming to the conclusion she did, in that instance, Long did apply in respect of the substance, and that the requirement that the employer to show more than the fact that there is an investigation had been done with. And that because that was not something which was contained in the code itself, then the commissioner was wrong in finding that the employer merely asserting that there is an investigation, which was common cause, that it was undertaken, and requiring the employer to prove more was what made her decision wrong and therefore reviewable. And on that basis, the judge then concluded that the award had to be reviewed and set aside on those two bases. So he found that there was procedural fairness and substantive fairness just on different reasons to what the commissioner had given. This case involved, Helen, a 1 month suspension, and the compensation awarded by the commissioner was 1 month's worth of salary. And it took 7 years to complete. It took 7 years to complete. So I think it's one of those, perhaps was a principal fight that the employer engaged in. But as I wrap up, it's really just a matter of saying when judgments are given or handed down, we need to be careful to make sure that we don't rely on the judgment. If our internal policy says something different, we always need to actively look at our policies and make sure that they are amended from time to time to comply with changes to the codes, to prevailing legislation and so on. And I know sometimes judgments go up and down, but it is important that we do so, particularly if those codes provide for better rights than what the courts rules from time to time. Thanks, Helen.
Thanks, Milton. Yeah, I mean, also at least in an academic lawyering, I think somewhere there in the 7 years. Thanks all. It's been lovely that you've been able to join us. I'm sure we're going to be interacting with a lot of you before the end of the year, but for those of you that we don't see, we wish you all the best for the end of the year, and we will see you at the next ELU next year. Cheers, everyone.
Thank you.